Well, welcome in. You are watching First Coast News' online coverage of the trial of three men accused of murder in the shooting death of Ahmaud Arbery. Ahmaud Arbery, at just 25 years old, was shot and killed in the Satilla Shores neighborhood of Brunswick, Georgia. This happened back in February of 2020. An arrest was made in that case 3 months later, in May of that year, and fast forward now to where we are, November of 2021, the three men accused of murder again in his shooting death, they are now on trial. So we know that everything has wrapped up in terms of jury selection, and just Friday we had opening statements begin. The prosecution did their opening statement, as well as two of the defense attorneys. We're going to get into that in just a bit because there's still one more that has not done an opening statement. After that, we did see witness testimony. There was one witness that has taken the stand so far. So today is day 2 of witness testimony. That's set to get underway in just about 30 minutes or so at 9 a.m. And joining us this morning is someone who's very familiar with these high-profile cases, trial attorney here in Jacksonville, Richard Kurtz. Richard, we thank you for waking up with us this morning. We appreciate it. I would normally say dark and early, but things are a little bit different right now with daylight savings, so the sun is out at this point. I want to delve right into this because you're paying very close attention to this, as are most of us. And I want to, first of all, explain to folks what was going on Friday in terms of why William Bryan's attorney did not give an opening statement, because a lot of people sat back and thought to themselves, how is this possible? How is he able not to give an opening statement until after the state rests their case? So if you can explain to us exactly what happened there to bring us to where we are at this point.
Certainly. It's a strategy that's used very rare, but I am very familiar with it. But lawyers, for the most part, have a hard time. The lawyers have a hard time not talking. And so even though there's been a couple of times where I wanted to, what the phrase is that we're going to reserve our right to give an opening statement, technically. And what that means is there is a rule of procedure that allows you to let the state go first, hear everything the state has to say. And in this particular case, where there's other co-defendants in this case, it would not be unusual for me to at least contemplate saying, I'm not going to give my opening statement. I want to see what you guys are doing. I want to see what how the jury's reacting. I don't want to oversell my case. So there's a rule of procedure that allows you to wait and reserve your opening statement until the state rests their case. Then if the defense is going to put on a case, that's when you make your opening statement and you tell the jury what you believe the evidence is now going to show. So it's an unusual strategy. Yeah. Most people don't use it. So people getting caught off guard does not surprise me that people got caught off guard.
The judge himself had to take a break, as a matter of fact. He said in his decade of doing this, he had never heard someone use that term before, saying that they wanted to go ahead and move forward with it. So he took a break, came back, and granted it. But if you can, in layman's term, give us the purpose, the reason why Gal would want to do this.
You don't want to oversell your case. Okay. You want to sit back and watch what they do. You know, whether you're going on the offense or on the defense. What I would do, and I've contemplated, though I've never been able to sit down and not stand up and make my opening statement, because the state usually says something that fuels me to get up and say something. But basically, I want to sit back and watch. I want to sit back and see what the prosecution says, what my co-defendants say, and then I could stand up and, having digested everything that I've heard and I've witnessed and I've watched how the jury reacts to what has already been done, so that I can then go in with credibility and believability and not oversell my case now that I've seen what everybody has to say.
William Bryan's attorney, Gal, has been raising eyebrows for weeks now. A lot of things that he says and does. We know just last week he said at a point, he raised his hand and said, you know what, I might as well just go ahead and get a mistrial. Go ahead and move for a mistrial. This is what he said, William Bryan's attorney. And everyone's sitting back like, is that even possible? What's going on? Ultimately, the judge said that that's not going to happen. But let's go back a little bit and talk about the reasoning behind that. So we know that the prosecution, in her opening statement, she said something that caused the defense to step back, like, wait a minute, you're not supposed to do that. The state cannot introduce evidence that there was a time lapse and just leave it hanging there. So we know that the prosecutor, she mentioned that there was a time lapse in between the shooting death, which was February of 2020, and the arrest that was made, which was May. They made an agreement beforehand not to mention that. And then that's what we heard Gal say that, hey, I'm going to move for a mistrial. So explain to us what happened there and why you believe the judge ultimately said, no, you can't have a mistrial.
Well,
a lot there, I know, to unpack.
No, no. I'm just trying to give you the layman's term answer to that. I mean, just because somebody commits a crime on January 1st and doesn't get arrested till March or April or May is just not that unusual. Okay, the fact that there was a delay in this particular case, people can point fingers as to why it was, since the prosecutor that was handling it has been indicted in federal court. So there's different things that need to be considered, but really it's just not that unusual. I mean, I've tried all the way to a verdict over 50 first-degree murder trials, and it's just not that unusual. I mean, I've had murder trials where they got reversed at the Florida Supreme Court, came back, and the date of the arrest to the date of trial is now 10 years or 8 years or 5 years. So that delay, it just does not offend me. And that's why the judge really, there's not enough prejudice for that. Now, having said that, they all had an agreement. They were supposed to follow the rules. And if you enter an agreement in a courtroom with the judge and a prosecutor and defense lawyers, you expect everybody to follow the agreement. And so when that came up, I think it caught him off guard, and because we had a deal, we all agreed we're not going to do this, and ultimately did it anyway. And so that was in violation of their agreement. You know, what do you do about it? I mean, do you sanction the attorney? You know, do you give them a $500, contempt charge, something like that, which I have seen things like that happen. But it's just not significant enough to sway the jury one way or the other. This jury is from that town. Everybody knows what time it is. Okay, so I don't think that 90-day delay or whatever the exact time period was is just not prejudicial enough. Now, the attorneys are supposed to play by the rules and follow the agreements to which they made. And when they don't, they could be subject to sanctions. And so that's really what happened. And to preserve your client's rights for appeal, you have to object and you have to move for mistrial. It does not mean it's going to be granted. 90% are not granted. So did he do what he was supposed to do based on the agreement and the violation of the agreement and make his objection and move for mistrial? He did everything he was supposed to do. So
that wasn't as odd as it appears to the rest of us from the outside looking in.
No, I've seen it so many times where, I've seen it like, I'm at the podium, I'm standing there, prosecutor's there, I'm there, judge is there, we agree to it, we call a witness, and within 30 seconds, there's a violation of the agreement. I mean, it happens when you get into a trial that's emotionally charged. The attorneys can get on a roll, they can get going, and they can just slip. And it's really not vindictive or malicious. It just happens. People misspeak, people say things they're not supposed to say. When it's passion, that's the whole deal.
You mentioned this being emotionally charged. We're going to get to that in just a bit. First, though, I want to welcome in folks who are just now joining us. You're watching First Coast News' online coverage of the trial of 3 men in Brunswick, Georgia, accused of murder. This is in the shooting death of a young man, 25 years old, Ahmaud Arbery. Ahmaud, we know, was shot and killed back in February of 2020, and now we are in day 2 of witness testimony in this trial. Joining us right now is trial attorney Richard Kurtz here in Jacksonville, who's very familiar with these types of high-profile cases. Richard, you mentioned emotion, and I want to take folks inside of the courtroom to fill them in a bit about what was going on there on Friday. We saw at a point Ahmaud Arbery's father get up and walk out of the courtroom. This was right before the prosecution showed the video of Ahmaud losing his life. And then there was another really impactful moment when we heard Ahmaud Arbery's mother, Wanda Cooper Jones, cry out in the courtroom when we saw the body camera video of her son just laying there. It was very gory. We saw blood as well. And then there was a juror who put a notebook over her face. She obviously could not see that. I want to get your reaction as an attorney seeing that on both sides. What would your reaction be?
Well, because of the nature of this case, I've dealt with many cases that were much more graphic than this, and that are the pictures and the videos are horrible. I have seen them. While it is the loss of a life, they're not the worst I've ever seen. But the family should have been coached by the prosecution that, hey, I'm about to show this. So if you want to step out, you can step out. Or I'm going to do this during my opening statement. I don't want any, passions. I don't want a mistrial because you're storming out of the courtroom. That's really on the victim advocate and on the prosecutor to try to control. I understand they have the right to be there, and it is very emotional. And watching your son or a family member get killed is obviously very emotional. But you want a fair trial. You want the jury to make a decision based on what they see and what they hear and the law that they're given. You don't want them to make their decision because they're feeling for the family. Sympathy, bias, prejudice should not come into play. But we're humans, and it is going to come into play. Yeah. And they're entitled to their emotions and feelings. It's just, as a trial attorney, you just don't like to see that because sometimes people, not this family, I'm not suggesting this family, but sometimes people orchestrate that to try to send a message to a jury. So to make their decision based on emotion. So I just don't like it in a trial, but it is a trial and there is emotion. So would I like it a little bit more sterile, so to speak? Yes, but they're entitled to their emotions and they're going through them. And hopefully the jury will make their decision based on the evidence and the law which they're given.
Let's talk briefly about the scope of this trial, how wide-reaching it is, because I received texts from you, from many family, friends, folks that I know from all over the nation saying that they were watching this online because our trial coverage is online on our website as well as our YouTube page. And we were streaming this, and so many people are interested in this case because of its wide-reaching implications. Let's talk briefly about that. You were out of town and heard about this as well.
Yes, I'm one of those hardcore Jaguar fans, as you can tell behind me. And we won yesterday.
Congratulations, by the way.
Thank you. But my wife and I went to the Seattle game last weekend, and we were out on the West Coast in Seattle, Washington, and woke up and had some coffee and turned on the news, and this case is on the news in Seattle, Washington. While we down here in Southeast, United States think that when we hear that it's national news, that, it's national news. But I was on the West Coast. I was looking at the Los Angeles Times, who is covering it as well. But this case is, when you say it's nationwide, it is nationwide. Like I said, I'm watching it in Seattle.
Yeah, definitely. I want to talk, Richard, as well about your take on things, watching it. Anything that really surprised you at all on Friday or just caused you to tick?
Well, nothing caught me off guard.
Okay.
I mean, because we know this is going to come. The attorneys are doing their best to represent their clients. These are not the kind of cases that normally roll through Brunswick, Georgia. Okay, they're not used to cases of this magnitude with this kind of coverage and this kind of pressure and this kind of stress. So I just hope that, and obviously we have a new prosecutor that had to take over the case. So there's just a lot of moving parts right now with the case, but nothing shocked me or surprised me. We can all trial lawyers always give opinion of another trial lawyer. They're doing the best they can with what they have is the simplest way to say it. So I'm proud of them. I'm glad they're doing what they're doing.
You mentioned a new prosecutor. That's getting in the weeds. We're going to do that later on as things are revealed throughout this trial. Obviously, you're talking about Jackie Johnson. We'll get to that. But back to Brian's attorney, Gal. So he keeps on suggesting filing a motion to sever. We've heard him bring it up again on Friday. We heard this during jury selection a couple of times. Where does that stand at this point? Is it still a possibility? What could possibly happen with that?
And this is something that should have been done a long time ago. And my personal opinion and professional opinion is it absolutely should have been done a long time ago. There's no reason for him to be in the same courtroom with them. I'm actually surprised maybe it's the prosecutor's decision not to get him to be a cooperating witness. Instead of having him sitting at the table, have him as a witness cooperating and providing testimony in this case. Bifurcating the trial now or separating them out is not going to happen. The only way it's not going to happen. I mean, there's just no way at this point, because the judge would have to declare a mistrial on his portion of it. And then the issue is going to ultimately be, can he be retried? Because right now, the jury has begun. So double jeopardy would have to kick in. There would have to be some deep thought into how they could separate this out. But 99%, this is not going to be separated. He is not going anywhere else. He's going to sit there all the way to the end. The only way he'll ever be separated from them is if this entire case is a mistrial and they get to go back to scratch, and he does it appropriately, because separating them out should have been done 6 months ago, not jury selection day or the final pretrial. It should have been done 6 months ago or a year ago. So it's not going to happen.
Let's talk about this motion to sever. Not going to happen right this one. It could be a very dangerous thing to do. We have heard Brian, he told investigators at a point, he was there as Travis McMichael stood over Ahmaud Arbery's body and used a racial slur as he stood over this man while he was there dying. For him to get up on a stand and say that against the defense, that would be detrimental. Let's talk about that.
Well, and that's the thing, like in Florida, in Georgia as well, just because you have 3 different people and their own theory, they may be 3 different theories of the defense. One may be self-defense, one may be whatever it may be as far as a citizen arrest.
Well, and at least one person be self-defense, yeah.
So there's all kinds of things that are going on, but you can have conflicting defenses and still have everybody sitting there together. Now, do I professionally think that's a good idea? No, but is it the law in Florida and in Georgia? Yes. So even though their interests are not aligned necessarily, they could still be tried together, and that's what we're dealing with. Now, as I said, this issue that we're talking about now, it should have been argued 6 months ago or a year ago. And I argue it all the time, so it's not unusual for me to say, that we want to do this, and that's where I hear, just because you have conflicting defense, I don't want to sit next to this guy. I don't want my client sitting next to this guy, because his case is going to bleed over onto me. And so, but that's the law. And so he's entitled to, the state is entitled to try them all together. And that's what's going on here.
Folks, if you're just now joining us, you're watching First Coast News' online coverage of the murder trial of 3 men accused of murder in the shooting death of Ahmaud Arbery in Brunswick, Georgia. Joining us right now live online is Richard Kurtz, a trial attorney here in Jacksonville. Richard, I want to ask you as well about this race. Race is something that has been brought up. It will continue to be brought up throughout this case. There's no question about that. Something that we have been hearing, even though the jury is seated, we're moving on with this trial. 11 white jurors and just 1 black juror, a black male. Your take on that, because you and I spoke behind the scenes, but we didn't get a chance to talk about that on camera as well. Your take on how things panned out in the end following this 3-week jury selection process.
Certainly. It's not unusual for, one side or the other side to try to, strike certain people, whether it's a minority, whether it's a female. I will confess, I've had trials where I didn't want a woman on my panel because I knew the women were going to hate my client. I mean, they were just going to hate him. He was a womanizer. And so I, followed the rules, followed the law, and used my strikes appropriately. And what happened in this case is clear, and the judge said it, that he sensed that there was a pattern of eliminating African Americans, which, while it sounds distasteful, it's trial work, and you have to take care of your client, and you want to do the best you can. You want to have the best jury that you think is going to be the fair jury. But I will tell you, that does not matter whatsoever, because I have seen juries in this situation all of a sudden empower that one African American. And I would not be shocked. I mean, I would not be shocked if that juror comes back as the foreman in this case.
That would be interesting.
Yeah, no, and I've seen it. I've seen it where I had like one little African American woman on my panel, and she came back. She was like 19, 21 years old, and she came back as the foreman and absolutely convicted my client, which I just did not see happening, but she did. So the rule against trying to segregate and discriminate during that began because prosecutors were the ones doing it. the prosecutors were the ones that were eliminating African Americans and putting all the white people on the panel. And then the law changed, and the United States Supreme Court came out with case law. And so you're not supposed to do it, but if you can come up with a race-neutral reason saying whatever it may be for that particular person, it's not that she's African American, it's that because of this, what happened to her in her life. And so as long as there's a race-neutral reason and it's legitimate, then even though the judge saw a pattern, there was enough race-neutral reasons that were legitimate, and that's what we dealt with in this jury selection.
You just briefly got into it, but I'm going to ask you to delve a little bit deeper to clarify for folks, because again, online you'll hear people, this is their, you put this in a headline, that's all you're going to hear about is this jury. How are there 11 white people and just one black on here? And how is it that the judge found that there was intentional discrimination? That was a terminology used, I believe, yet and still we're moving forward with this. Explain that, please.
Yeah, the case law is such that you're not supposed to, strike minorities or whatever it may be, whether it's race, whether it's religion, whatever it may be. Some people don't like Catholics on their panel. Some people don't like school teachers on their panel. So there's various reasons to strike people, and you don't know what their demographics are or what their background is, or whether they have been a victim of a crime, or whether they, their family member has been a victim of a crime. So there's other reasons to strike people, but doing it systematically and in a pattern causes problems, and it causes great concern. And it's still litigated all the time in every state in the United States, because one side wants a certain panel and one side wants a different panel. And so while it's clear what's going on, and because remember now you have three different defense lawyers in this case. So that means I can strike Keitha, I can strike, Tim Deegan, I can do this, and then my colleague over here, he's doing the same thing. So by the time you get three different defense lawyers using all of their strikes, it becomes much more apparent what they're doing. Whether it's just me trying a case by myself, my number of strikes that I can use peremptory strikes is low. And so it may not be as obvious if I were to do it. And just to make sure that your listeners are clear, there are two different kinds of challenges to a jury. One, to a juror, potential juror, one is a cause challenge, that this person just can't be fair. They just said, hey, I've already made up my mind, this guy's guilty, whatever it may be, and that's a cause challenge. You're challenging them for cause, which doesn't use your number of peremptory strikes, okay? Cause challenges, it's clear to everybody this juror can't be fair. Now we're on to peremptory challenges, okay? And a peremptory challenges, I just don't like her. I just, I don't like the fact that she works for, this particular employer. I don't like whatever it may be, and I say he or she. So then you can use those, and that's what happened in this case, because now you have three jurors, so you have three times as many peremptory challenges, and they're all on the same mission. And so it became obvious that what they were doing, but legally they could do it.
It's the law. It's the way our system is set up. We only have a few more minutes. Richard, if you can, give us a quick look ahead, what we can expect today. I know this is not your case. Let's make that clear, by the way. Richard is just very experienced in these types of high-profile cases. He is not at all affiliated with this particular case out of Brunswick. But if you can, give us a look ahead to what we can expect today.
Well, what you typically do, the way cases begin is from the beginning. The prosecutor has to tell the story, okay? And so, it's easy to know how the story ended, but what we're going to begin with today is the beginning of the story. We're going to go, the prosecutor is going to go first, as they always do, and they're going to start showing the timeline of how we got here. And so what you're going to get is a bunch of first responders. You're going to get some maybe 911 phone calls. You're going to get the people that first responded to the scene, the officers who first did a canvass of the neighborhood to talk to, anybody who might have seen anything. You're going to find people, the EMTs are going to start coming in to talk about, attempts to resuscitate them, things of that nature. So really what we're going to do is we're going to begin telling the story, and that begins today. And that's what the prosecutor is going to do.
Richard Kurtz, as always, we appreciate your time. Thank you so much. We'll be seeing you again throughout this trial. I'm certain of that. We don't have a timeline exactly as yet as to when this could possibly wrap up. Hopefully we will in the near future, but at least we finally got there, right, where we got things going. We're on day 2 right now of witness testimony. Folks, you've been watching First Coast News' online coverage of the trial of 3 men accused of murder in the shooting death of Ahmaud Arbery. We're going to go ahead and let you tune in now to court. We know court is set to resume at 9 this morning, again on day 2 of witness testimony. Richard, again, thank you.
Thank you for having me.